pay bankruptcy fee online, you can but not by credit card. A ruling in a proposed class action against a defunct Orlando, Florida law firm claimed a lawyer goes against government law if he instructs a client to pay his bankruptcy-related legal costs making use of a credit card. How about in Canada? I would suggest that the outcome in Canada would be equally as disastrous for both the bankrupt and the licensed insolvency trustee. However, that does not mean that a bankruptcy trustee cannot encourage online payments, just not those using a credit card. I think it is important to first understand what the various online payment choices are. Credit cards. Interac online debits. Online transfers include online e-wallet and electronic peer-to-peer transactions initiated through online services and providers, which are either pre-funded or linked to deposit accounts at financial institutions, for example, Interac e-transfers, PayPal and Tilt, and prepaid App Store cards, or virtual cards. Credit cards are the most used for online payments. But as you can see, there are ways of making online payments using cash. My view is that it would be unlawful to use a credit card for paying a bankruptcy fee in installments or in one payment. My reasons are as follows. Using a credit card to charge expenses or take cash advances against knowing that you are about to file for bankruptcy and therefore we will not repay it is fraud. Fraud, of course, is illegal. So the insolvent debtor, about to become a bankrupt, will be in trouble. Just like in the USA as cited by the court that I mentioned at the start of this blog. Likewise, any bankruptcy trustee who accepts payment by a credit card in the name of and from the insolvent debtor would be in trouble. The same trouble would befall the professional if he or she encouraged the insolvent debtor to take a cash advance against the credit card to pay bankruptcy fee online. Here's why. It is against the rules of professional conduct of the Canadian Association of Insolvency and Restructuring Professionals, CARP. The rules require a member to maintain the good reputation of the profession and perform professional services with integrity. The General Rules of the Bankruptcy and Insolvency Act, Canada, BIA, requires that a bankruptcy trustee maintain the high standards of ethics that are central to the maintenance of public trust. It also requires that trustees shall not assist, advise or encourage any person to engage in any conduct that the trustees know, or ought to know, is illegal or dishonest, in respect of the bankruptcy and insolvency process. Using a credit card to charge expenses or to take a cash advance, knowing you are about to file for bankruptcy and therefore we will not repay it, is fraud. So the insolvent debtor, about to become a bankruptcy will be in trouble. Likewise, any bankruptcy trustee who accepts a payment or cash from an insolvent debtor to using his or her credit card just before filing for bankruptcy will also be in trouble. The risk for the trustee, of course, is serious, the loss of his or her license to practice. But what are the risks for the insolvent debtor? For the undischarged bankrupt, in my view, the risks are twofold: I, criminal, and 2, civil. The criminal repercussions are obvious. One or more fraud charges would be laid and a criminal conviction, jail time and a restitution order would be the result. The credit card issuer would certainly oppose the bankrupt's discharge. In the meantime, the credit card company would obtain a lifting of the stay of proceedings which protects an undischarged bankrupt from lawsuits, in order to start litigation to find that at least the debt incurred by the debtor to pay for the Canadian bankruptcy costs was a claim against the debtor for a debt not released by order of discharge. So the credit card issuer and the trustee, probably by now the substituted trustee, must oppose the bankrupt's discharge. I am certain that the oppositions would be successful. The most likely result would be that the court would flat out refuse to hear the bankrupt's application. The result of this is complex and should be discussed in a separate blog. Suffice to say that the bankrupt will have a very hard time ever getting out of bankruptcy without showing that restitution has been made. Even then, I would expect the court to only grant a discharge upon certain conditions being met. In other words, it would be a disaster and a mess for both the trustee and the bankrupt. These are my reasons why I feel that to pay bankruptcy fee online using cash is fine, but not by a credit card. Note to professionals encouraging clients considering bankruptcy: tell them to keep that plastic in their wallet. Are you facing financial problems? The Ira Smith Team can develop a restructuring plan for you. We understand the pain and stress you are feeling thinking that you may just soon hit the wall. Our debt settlement plan process can ease this stress. Call the Ira Smith Team today for your free consultation. We can end your pain and put you back on a healthy, profitable path, starting now.
I hope you enjoyed the video. The Ira Smith Team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.